everyone, and welcome to our presentation on moral rights in the workplace. This presentation was created by Tiffany and Karla Patino. Our objectives are to understand what employee rights are, understand how moral rights and ethics go hand in hand, explain what it means to have the right to work, understand how employment at will and due process in the workplace correlate, and know what participation rights, freedom of expression, employee health and safety, and privacy in the workplace mean, and how they relate to your personal beliefs. We want to start by asking, what does moral rights mean to you, and how do you think you apply moral rights in the workplace? You can go ahead and pause the video and take a couple of minutes to think about this. For this presentation, we're going to be referring to rights as human rights, since we're discussing people's moral rights in the workplace. The definitions for morals is relating to the standards of good or bad behavior, fairness, honesty, etc. that each person believes in rather than the two laws. And the definition for human rights is human rights are rights inherent to all human beings, regardless of race, sex, nationality, ethnicity, language, religion, or any other status. Human rights include the right to life and liberty, freedom from slavery and torture, freedom of opinion and expression, the right to work and education, and many more. The book explains moral rights are when important human interests are jeopardized by the actions of others. So usually when you believe something is right, it's because that is how you were brought up to think, ethically. And ethics includes what we believe is right or wrong in a morals type of way. So here's a video that gives an explanation of morals and ethics.
A friend asked me the other day, what is the difference between the terms morals and ethics? And the simplest answer is none whatsoever. The term morals derives from the Latin word for manners, customs, and ethics derives from the Greek term for manners, customs. They are therefore perfectly synonymous. And having said this, some philosophers have assigned different meanings to the two terms. In Cano, for example, morals designates the ensemble of first principles, and ethics refers to their application. Other philosophers refer to morals as the theory of duties toward others, and to ethics as the doctrine of salvation and wisdom. So there's no reason why different meanings should not be assigned to these terms, but essentially. A friend asked me the other day, what is the difference between the terms?
So how do we behave morally right in the workplace? Some ways include being kind to your coworkers, even if you don't know or maybe even like them. Respect their opinions, even if they differ from yours. And you're fair to everyone in the workspace. In this chapter, moral rights will be discussed in the terms of employee rights. There are three employee rights that are most common in terms of an organization. There's legal, contractual agreement rights, and individual rights. In Texas, all employees are legally required to pay their employees minimum wage, and in Texas, the minimum wage is $7.25 an hour. Employers, they may count tips and the value of meals and lodging toward the minimum wage as well. Equal opportunity prohibits employers from discriminating against people who are applying for a job and even their current employees. The discrimination we're talking about includes race, gender, age, disability, and any other attributes of a person. People are allowed to form or be part of a union legally while working for a company without fearing for termination because of their union status. And also, employees have legal rights to various kinds of safety, from being protected from sexual harassment to employers providing safe work conditions. Here's a question. Do all employees have a legal right to a set minimum wage? If you answered yes or true, then that's correct. Every worker has the right to be paid the standard minimum wage. Now going into contractual agreement rights. The contract you sign when accepting employment is important because it shows the employee what the organization expects from them, and it's the moment that an employee agrees or disagrees with the amount that they're being paid. They're also able to access information about holidays that they're allowed to have off, and they can even sign up for benefits like healthcare and pension funds. Now on to individual rights. These individual rights, they're separate from legal and contractual rights within an organization. These are rights that are in the Constitution that the government has ensured we cannot have stripped from us as human beings. So, an example of employee rights is if an employee had a right to freedom of expression, then an employer could not deny someone his or her job on the basis of his or her political expression. So, let's go ahead and play this video, and while you're listening to it, think of what comes to your mind when you hear the phrase right to work. And do you think that everyone should literally be allowed the right to work?
Whatever we seldom we work to earn the right to work, 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 to earn the right to give ourselves the right to buy ourselves the right to live, to earn the right to die.
A right to work has many meanings, but one meaning in the political aspect is that people have the right to work without joining a local union. However, when someone is applying for a job that isn't a union, they require that the employee be part of the union rather than a free rider. A free rider would be someone who works in a union environment and receives all the union benefits but doesn't have to take on the responsibilities of being in a union, which is a rule that makes it fair for all because why should one person have to pay union fees and another doesn't but still receives the same benefits and wages? The right to work law was passed to further protect employees who want to unionize by making it illegal for employers to coerce employees into promising not to join a union, and in exchange they will receive job security. The right to work law states that they believe wages and benefits are chosen better when it's done solely between employee and employer. However, for there to be fair bargaining, both employee and employer would need to be able to have the freedom of being able to accept or reject in the situation, which honestly could be hard if the employee, for example, is wanting a raise, but the manager can't give a raise because the company doesn't have the funds at that moment to increase their wage. So, in this case, there would be no right to work where bargaining is not allowed. People need a job in order to fulfill most of their physiological needs, like food, water, shelter, and clothes. The right to a job helps them obtain those needs by allowing them to work for it. Working also helps with one's self actualization in the manner that it helps humans to have a fulfilling life. Although this does bring up the question that if everyone has the right to work or the right to a job, then who's responsible for supplying those jobs to each person? Private employers, they can hire people, resulting in providing some people with the right to a job, but they can't hire every person, or sometimes they can't even afford to keep every employee, and they're only able to hire so many employees. In lieu of private employees, we can rely on government assistance to fulfill the right to work in society. There are many ways that the government can help, like providing incentives and subsidies to private employers. It's also the government's responsibility to assist citizens with finding employment opportunities. Both of these employment assistance opportunities show that it is reasonable to claim that people have a right to a job. So once a person is hired and have fulfilled the right to work, this is where due process comes into play. For example, a private employers, they're not required to hand out a job to just anyone, but once someone is hired, they are required to provide job security through due process in the workplace. When we talk about due process in the workplace, we are referring to the right employers have to fire an employee for a good cause, but they cannot be dismissed for no cause or morally wrong cause. To ensure when firing an employee is done in a legal way, employers have a set of legal and company created procedures to follow when deciding if an employee is needing to be fired, so it's not arbitrary. So, an example of what would be written in the handbook when you're using due process in the workplace to fire somebody includes things like not completing tasks, being intoxicated while at work, having too many absences, stealing from the company, and some other topics as well. However, it is impossible for every organization to list everything a person can do to be fired. So that's where the due process comes in to help employers know if dismissal is the proper action to take on the employee. These procedures, they help with creating an outline, like for example, would be a manager writing, I'm firing Tiffany for reasons of her A, being late, B, not performing all her job duties, C, not following company policies, and D, she doesn't listen. Without due process in the workplace, society is sanctioning an institution that allows individuals to exercise the power they have over others without restraint. Go ahead and watch these two videos. One is like in the employer's point of view, and the second would be in the employee's point of view of being fired or being the one firing somebody.
Nobody likes to terminate or fire an employee, but there is a wrong way and a right way to do it. First, gather all the information that you have as it relates to that individual's performance or the inability to be successful in their role. Secondly, choose an appropriate time and place to conduct the termination. If there's client confidentiality issues or toxicity that's happening within the workplace, you want to just remove that as quickly as possible and not wait for an opportune time of the week. And then finally, you want to make sure that this has become a learning lesson for you. It's always difficult to terminate and lose employees, but when it happens, it's a great opportunity for us to reflect and determine what went well and what did not go well and where can we improve upon that. Evaluating this will help you to be more successful with your next hiring.
Excuse me, yes, I was fired and I'd like to sue.
What happened?
Excuse me, yes, I was fired and I'd like to sue.
What happened? Marcy, write this down.
Writing. I didn't do anything wrong.
Marcy, stop writing. Technically, you don't need to do anything wrong for your employer to be able to fire you.
You don't understand. My boss, he was a jerk.
Being a jerk ain't illegal. If it were, half this town would be locked up.
And he fired me for complaining that we weren't getting our lunch breaks.
Now we're talking. Marcy, write this down. Wrongful termination is generally caused by one of these three categories: discrimination, harassment, or retaliation. Now, if one of these happened to you in the last 2 to 3 years, depending on the case, then you, my friend...
Excuse me, yes, I was fired and I'd like to sue.
What happened?
Right, so there are four major counter-arguments that are brought up when we talk about due process in the workplace: freedom, fairness, property rights, and efficiency. Let's take a look at each one. True or false? Can an employee be terminated for speaking up in the workplace? What do you think the answer is? If you answered false, then that's the correct answer. Now we would like for you to think why that is false. take a few moments, then play the video. In this argument for freedom counter-argument, an employee should feel like they should be able to speak their truths without their wages or work conditions with management, and not fear that they're going to have some wrongful termination or that they're going to be reprimanded for it. The counter-argument of fairness argues that it should be okay to fire someone for any reason, like an employee can just quit. However, there are vast differences between the two. When an employee quits for no reason, it really doesn't affect the organization much because they're able to hire a replacement fairly quickly. It could have a negative effect on the employee, though, because they have to go out and search for a job, they lose their form of payment for a while, and they could have it hurt their reputation when they're applying for another job. Now, property rights counter-argument. Employers, they may hire the employees and own the business and materials used within the organization, but they do not own the employees. So they can't just, dispose of them at will because employees, they're human beings who have feelings and deserve basic human respect. For the efficiency counter-argument, this counter-argument, it's just most concerned for those who are underqualified and the workers, honestly, the workers that slack off. Due process rights, they're important to keep the workplace ethical and ensuring moral rights in the workplace are present. Now we're going to go ahead and talk about participation rights. So managers, they have the authority over their employees by being able to tell them what tasks they need to complete during the workday. They also schedule their work times and they're ensuring that they're doing what is needed. But they do not have sole power over employees, that they can't just tell them what to do in a rude way and not allow employees to voice their ideas or let them collaborate in an inclusive working environment. So employees, they should have the right to participate and collaborate on decisions managers make while working. The employees, they should be able to do this and be treated with respect and fairness from their employers. With respect, employees should have the opportunity to use their voice to help make decisions that affect their work and not fear that they're going to be replaced and lose their jobs because they just want their input to be heard. And to maintain a fair working environment, employers, they should make sure that they consider all employees that can be affected by a possible policy change and allow them to speak their opinions before that change is taken into effect. By giving employees the right to participation, it will result in utilitarian consequences that will make for a better work environment. This shows that employers have enough moral value for their employees by encouraging them to participate in the management decision-making process. Having employees participate can also help with the employees' self-worth, showing that their opinions and thoughts for the workplace matters. Allowing employees to have their participation rights can also help with employees being happier in their work life by giving them meaning and value while performing their daily work tasks. Because let's face it, it can become redundant and mundane, especially after performing the same tasks in the job that you've had for, let's say, more than a year. Allowing employees to voice their concerns or input is essential to maintaining participation rights and allowing the employees to keep their right to free speech without fear of repercussions. Now, freedom of expression. So, in the United States, all citizens have the right to free speech, which was written in the Constitution to allow everyone the opportunity to express their beliefs without fear. In the workplace, employees, they should be granted the right to their individuality of being able to speak freely, but there are limitations that would need to be imposed. Talk about the Demora and Briskman case. Google had this employee, James Damore, who posted an article called Google's Ideological Echo Chamber. He used his freedom of expression to voice the diversity of the workplace, but in all honesty, we believe that it was in a manner that belittled women in an engineering workplace because he basically stated that women do not have the biological capabilities to perform as good as men in this type of work environment. This is where freedom of expression in the workplace should have limitations because it transitions from voicing one's opinions to becoming hostile and discriminatory. So, do you think that there should be limits to freedom of expression? If yes, then how do you decide where to draw the line of what should not be spoken in a work environment and how to keep your freedom of expression? And if you don't think that there should be any limits, what are your reasons for that? Take a few minutes to write 3 to 5 sentences about what your answer is and why. Feel free to post your answer within the comments section if you'd like. Okay, so going back to the Damore and Briskman case. Was it morally right to fire Damore? We believe that in this case it was just to fire him or anyone in the matter that uses their freedom of expression, but in a manner that can hurt the company's reputation. He blatantly spoke about a woman in a degrading way. It is company policy for many corporations to protect the feelings of all employees and ensure harassment or discrimination does not occur in the environment, protecting their employees' feelings. Allowing employees to speak freely but ensuring they remain respectful ensures the safety of all employees and helps to maintain a positive working atmosphere. Now, employee health and safety. Honestly, it is impossible to have everybody be entirely healthy and safe because there are various factors to health and safety. Instead, we're going to be focusing on the level of risks that are acceptable in a workplace environment, which in turn makes for a safe workplace. The question we seek to answer is what risks are acceptable to occur in the workplace that keeps an employee safe? So we can measure risk and relative risk and determine if it is a risk acceptable for employee safety through gathered data of the kinds of harms that there are and how they affect people. To find if the level of harm is acceptable through data, we see if the level of harm from a specific activity is equal to or less than the probability of harm from some more common activity. Then it would be easy to conclude that this activity faces an acceptable level of risk. However, this method of analyzing safety has problems that come along with it because it doesn't take into other factors into consideration when evaluating the category of risk. To measuring risk, it does have problems. One being that it blatantly does not take into account how employees feel about a risk that affects their health and safety in the workplace. And it also silences their right to freedom of expression and participation rights in the workplace. Secondly, it makes it look like the company perceives health and safety as preferences that can be traded off against competing values. Lastly, it makes it seem like all risks are in the same category rather than acknowledging the level of differences each risk has and the scenario that surrounds that risk. For example, the risks that can occur in the workplace are not risks that employees have control over or necessarily expect to occur, versus the daily risks we have control over, like smoking cigarettes. So, to use these two vastly different examples in one data set to gather results, it's just not the best approach, especially when it comes to workplace health and safety. Other than the data collection method, there are other approaches that can be considered to determine employee health and safety. There's individual bargaining between employees and employers and using government regulation. So there are pros to using the individual bargaining approach, like employees being able to use their employee rights and their participation rights to use their voice to their employers and ask for a pay that they deserve. It's also expected that employees will know the level of risks they can handle when working a job, which also determines their pay being more or less. However, there are cons to this approach because not every employee has the opportunities that free market theory describes to choose the level of risk they want. Also, being paid higher for a riskier job isn't always the case. Most higher risk laborers get paid lower wages and they don't have the opportunity to bargain. In our opinion, allowing an employee to complete a labor job and paying them for higher for that job, it's just not morally right, especially in the workplace when employers should focus on protecting their employees from unnecessary harm. Government helps to set standards for employee health and safety within a workplace. One big way that they did that was by establishing the OSHA, which establishes the standards for employee health and safety. The OSHA uses scientists and medical experts that work for them to determine the level of exposure employees are released to and if it's a technological or economically feasible. When a company passes as a yes for being feasible, then the standard will be established at this point. But if it's a no to passing, then the standard will be set to the lowest level. These standards these standards make it to where an industry is required to meet the highest standards attainable within technological and economical reasons. Some people believe that OSHA should use a cost benefit analysis approach when setting the standards, rather than just the feasibility approach. With cost benefit analysis, they want for the standard to take into consideration the way the benefits outweigh the cost. But this could lead to ethical issues because doing this would be accepting that some people will get hurt, but the benefits for the business is worth it. Employees are essentially the backbone of a company and ensuring that the corporation runs and they also do the work that and complete the work so that the company can have the profits. So, ensuring their health and safety should be a top priority for employers and giving them the moral rights in the workplace that they deserve. Okay, privacy in the workplace. So, employees they should have the right to privacy. But in today's world, with all the technology that we have access to, like social media platforms, it really is impossible to expect full privacy, especially since the stuff we put on our personal social media includes personal information like what we did last night, what we ate, who we hung out with, and how we're feeling, and so much more. Instead, employees they should have basic privacy in aspect like their personal information not be accessed. And when we talk about personal information, I mean like a company should not be able to access your personal data such as your emails or, stuff from your personal phone. They should not be able to access text messages, your personal pictures or videos when that's your devices and they have nothing to do with the company. So, when we talk about contractual models of employments, we use contracts when hiring employees to help both parties understand the level of privacy an employee has and the level of comfort an employee feels for an employer to have. These contracts help a workplace to maintain an ethical work environment because they voluntarily consented to sign the contract and they agree with the amount of information the company can access. Now, you should have a better understanding of how moral rights in the workplace is created using employee rights, the right to work, due process in the workplace, participation rights, freedom of expression, employee health and safety, and privacy in the workplace, and using ethics to create a positive work environment for employees. So, we encourage you to use this knowledge on how to have moral rights in the workplace for your future or even your current careers so that you can be the best coworker and leader that you can be. Now, we have attached a Q&A for you to go ahead and answer to the best of your knowledge. Thank you.